एक रिसेंटली बहुत ही इंपॉर्टेंट मुद्दा मुझे लगता है कि वो भी डिस्कस करना बहुत ज़रूरी है, आपसे आपके ओपिनियन लेना बहुत ज़रूरी है लोगों के लिए. ट्रिपल तलाक का जो इशू है, एक तो ट्रिपल तलाक के डिटेल्स आपसे मैं जानना चाहूँगा, और जो पनिशमेंट है ट्रिपल तलाक के जो लॉ अभी पास हुआ है, are you with that punishment which has been passed by the parliament? How impactful is this? How much impact will it create to protect that women who have been always on the receiving front? How do you react to this, Mrunalini?
So before that, I think I would like to tell your audience that the Indian laws of marriage, divorce, child custody, inheritance, etc. Our personal laws are based on our religion. So we have a Hindu Marriage Act, we have a Parsi Marriage Act for the Parsis, the Christian Marriage Act, the Sharia law, of course, governs our the Muslims. So the Triple Talak is a part of the Sharia law, which is a 1937 law, which is here. Now, what does Triple Talak mean? That the husband has the unilateral power to pronounce talaq 3 times in the presence of 2 male witnesses, and the qazi can declare that he has said it in my presence and the talaq has been done. When a number of cases came to the Supreme Court, where the cases of instant triple talaq came, so which means the husband would say talaq, talaq, talaq in front of 2 people. He would write it on a piece of paper and he would just sort of send it to her, or some of the cases were even on a WhatsApp the thing was sent. And then the girl, when she, suppose she had children or she had parents, and they were just worried, all of a sudden this entire thing has fallen on us for no fault of ours, or without giving us any notice. What the Supreme Court has done in Shaira Banu's case in the Supreme Court was that they have held that the instant triple talaq, which is talaq, talaq, talaq in one breath, is illegal, null and void, and cannot be used as a ground for divorce. And to make it more effective, and this was more for the Muslim women because most of them were at the receiving end, they have made it, and to make it a deterrent and to make it effective, they have put the clause of a punishment in the event a person does that. Now, a punishment serves 2 purposes. It's reformative, it improves you, or it's a deterrent. In my view, the punishment, though it may sound harsh to the person, actual implementation should not be done to that effect, because ultimately there are other people who are interested people in the society. I don't want to name anybody or any organizations or any individual who want to have their supremacy over it. But the law has to be just and social and equitable to everybody concerned. So that is why the courts had to intervene and to bring this. But today, Ashokji, even today, when a male husband, when a husband that is wants to take a divorce under the Muslim law, under the Sharia law, the only thing available to him is a triple talaq, but not instant. So he has to give an intention of divorce today, in say first month, and say that I'm ready and willing to take care of all your provisions. Then month 2, month 3. If there is no response or if there is opposition or whatever, after the 3rd month, then he gives a talaq in the presence of that. That could be held to be a valid one, because the woman was given enough opportunity for her to come forward or to agree or to do whatever things are there. So even today, the triple talaq is the only way a husband can sort of take talaq from this. But what the law has forbidden by the Supreme Court judgment is the instant triple talaq, which caused misery to millions and millions of Muslim women otherwise who were caught unaware, because most of the community people were, there was ignorance, there was no knowledge, no money, nothing of these things were there, and they were just subjected to this. So, I'll tell you an example. I had somebody who had come, we do a lot of pro bono matters, where a girl came, very pretty girl around 19, 20 years of age, and she came with a burqa and hijab, and her father came, and he said, the father was a tailor in one of these designers people, so very simple, modest work. And they came and he was crying and she was saying, so then he said कि मैडम जी कल इनके हस्बैंड ने व्हाट्सएप पे ट्रिपल तलाक बोल दिया, कागज़ पे लिखा और उसका ऐसे मतलब ये बॉल बना के छोड़ दिया, और अभी तो हम क्या करें, मेरी लड़की 20 साल की, she's not even studied much, and what is to be done. And that was the time where the judgment was being, sort of being debated and argued. So then ultimately we did go to court and tried to prove that this triple talaq, because the judgment came to our thing and got the girl to a large extent, whatever it was there. So this is a reality that is happened, which is I've seen in my experience. So the law is good. The law should be a deterrent, but the law should not be so harsh that it can sort of, take anybody to its logical end. Punish him or just give him some punishment so he realizes, or cancel this. But at the same time, even if you deny the triple talaq divorce as a valid one, the polygamy allows him to get married at the same time. So wo bhi ek nuance hai, but that's a different discussion that is altogether there. But this is the law as far as triple talaq is concerned.
What's your take on Uniform Civil Code?
So my view as a lawyer on the Uniform Civil Code is absolutely I am for it. It's a part of the directive principles in the Constitution of India. I really wonder why they did not make it part of the fundamental rights, because that would have saved a lot of things. But I think the situation was in 1950 was different when the Constitution was drafted, and there were various issues that the drafters had, the draftsmen had to take care of that. But having said this, the reason for why I favor Uniform Civil Code is because it brings about uniformity, as the word says. It brings about equality. And I believe that this would be more useful to the Muslim women. Today, when we are talking about empowering the Muslim women against whatever the atrocities of their laws are, etc. are, I don't believe we are impinging on their religion. We are not impinging on their religious practices. For example, even under for the Hindus, we had barbaric things like sati. We had barbaric things like widow remarriage nahi hota tha. You needed people like Savitribai Phule, you needed like Karve, who in Maharashtra, who came up and brought about this widow remarriage act. So we Hindus also had certain practices which were quite barbaric, but we have done away with. So whatever is not correct, whatever is oppressive to any section of the society, any gender, should be done away with. You cannot take the umbrage of religion for that. No religion says that the people should be either tortured or they should be at the receiving end. Considering all these situations, I am of the opinion that Uniform Civil Code, and this is my opinion as a lawyer, I have nothing to do with the politics part of it or whatever is being done. I'm purely talking as a lawyer. That if you have a uniform criminal code where whatever gender, whatever religion, whatever you are, it is applicable to both. Why should it not be in a manner that it is also applicable in civil matters of child custody, of alimony, of inheritance, of share in the father's property or parental property or whatever the other things are. So I am for it as a lawyer with a little bit of, of course, we don't have a draft. We just have one draft of the Uttarakhand which has come, but that's not a classical draft, I would say. They would need to do that. They would have to do a lot of trimming. They would have to do a lot of things which are there. But in principle, I think if we have it, there'll be less litigation. There'll be more uniformity in this rather than use A religious law and B religious law and go to the courts.